Okay, I take it that every one of you can actually see the slide before you. Please indicate by a show of hands or thumbs up if you can see the slide before you. Okay, thank you very much. You can all put your hands down. Thank you, everyone. I've noted all your hands. Okay, we are on page 169 of your study guide, the effect of intoxication and provocation on criminal liability. Now, when we reach study unit 12, you will notice something very interesting. You will notice that we have effectively covered all four general elements of liability. We have covered the act, we have covered compliance with definitional elements, we have covered unlawfulness, and we have covered culpability. So we have explained in each instance what is required to satisfy a particular requirement and the factors that affect it or exclude it in terms of the principles of our law. So when we come to Unit 12 and we speak of the effect of intoxication and provocation, we are speaking about the effect of them on those elements of liability. So which of those elements of liability does intoxication affect? Which of those elements of liability does provocation affect? And what are the consequences? So you will see as we go through this particular unit, Unit 12, that it's not merely the presence of intoxication that excludes liability. It's not merely the mere proof of provocation or emotional distress that excludes liability. The question is, for the court always, what is the effect of those once established? What is their effect on the elements of liability? So just to recap, as we usually do, we covered the first two chapters way back at the end of April, and then in the months of May, from the beginning of May, covered the act, covered definitional elements, covered unlawfulness 1, unlawfulness 2. We covered culpability and introduced the concept of contemporaneity and the concept of criminal capacity. Then we went on to cover intention. Oh, no, before intention, we went on to cover mental illness and youth. Then afterwards, we covered intention in study units 9 and 10. We spoke about mistake, the concept of mistake, and the concept of apparatus ictus. We went on to cover the other form of fault, which is negligence, and we spoke at length, or at least covered the understanding of the reasonable person test over the years, recognizing that whilst as early as 1933, the test was very much strictly objective. Over the years and over time, because we live in a diverse society, the concept of reasonable person has had to evolve to understand conceptions such as race relations, conceptions such as cultural beliefs and ethoses of a pluralistic society such as ours in South Africa. We covered the test of the reasonable person test, spoke at length about its particular components. And so we are here now on page 169, starting with intoxication. Now, for you to be able to understand how the law has dealt with intoxication and what the present state of our law is, you have to have an understanding of our brief history, well, our long history really, but I will say briefly in the sense that I'm going to cover it briefly. We are talking, and our focus is on instances of voluntary intoxication. So these are instances where you go and you consciously purchase alcohol. Unfortunately for many of you now, you are unable to purchase alcohol because we are on level 4. And there's a ban until the 11th, so just hang in there. Nevertheless, we are talking about those instances whereby you purchase alcohol and you drink for yourself, whether it be in the comfort of your own home, as is the case now, or if we were at lower levels, you would be in your clubs and your taverns or your restaurants. We are not talking about instances where a person spikes your drink or you become intoxicated in an involuntary manner. In those instances, the law says that you have a complete defense against liability. So if, for example, you are at a bar and you were drinking and you were your drink was spiked unbeknown to you, and you become intoxicated, and in the course maybe you are involved in a brawl and you assault somebody. In those instances, because you were intoxicated involuntarily, then you will not be found liable for assault in such instances, because you did not intend to go about it becoming intoxicated. So that will be involuntary instances of intoxication. So we are focusing in this entire unit on voluntary intoxication. Let's distinguish between at least 2 other instances briefly. There's a concept called the actio libera in causa. This is where someone does not have the courage to perform a criminal act and chooses to drink so as to make themselves an instrument to perform that criminal act. In that instance, if you drink for courage and you perform that crime in the situation whereby you are intoxicated and you do not understand what you're doing, or you are unable to foresee and your criminal liability is affected, in those instances, the law does not provide a defense for you. You will be held criminally liable for your behavior, because when you decided to drink, you already had the unlawful act and the culpability, at least in the form of intention at that time when you began drinking to perform that crime. So it's called the actio in libera in causa. You will be liable. The law will not excuse you from committing the crime if you drank for courage. There's also the other instance whereby intoxication leads to a mental illness known as delirium tremens. Delirium tremens in such instances is dealt according to the provisions of Section 78 of the Criminal Procedure Act, mental illness. So because it's a recognized mental illness, in those instances, what will happen is that the accused will not be found criminally responsible, but will be sent to a mental institution. So instances of delirium tremens are dealt with as instances of mental illness. But for the remainder of what we're going to talk about here, we're going to focus on the remaining instances of voluntary intoxication. As I said, those are instances whereby you go and you enjoy your drink, and in the course of enjoying your drink, you perform a criminal act, and the question becomes, how severe were you intoxicated, and what impact will it have on the elements of liability? Now, prior to 1981, there was a concept called the specific intent theory. If you have opportunity to read cases like Johnson, 1969. Okay, just a minute. Let me just reflect on it. If you read cases like Johnson, 1969, 1 SA 201A, or cases as old as R versus Borg, 1916 TPD 9303, those cases established that before 1981, the law did not allow intoxication to be a complete defense. So if, for example, an accused did say and did establish that because of intoxication, they were unable to control their bodily movements, or they acted involuntarily, or they lacked criminal capacity, then what would happen is that the courts would say that all that intoxication does for you in that instance is to eliminate a specific intent, a crime requiring specific intent, and they will punish you for a crime requiring ordinary intent. So, for example, murder was a crime requiring specific intent. If there was proof of intoxication, then what happened would be that you will be guilty, you will not be guilty of murder, but you will be guilty of culpable homicide. Another crime that required specific intent is attempted murder. If you were charged with attempted murder and it was established that you were intoxicated, all that would happen is that it will eliminate that attempted murder charge. You will not be found liable for attempted murder, but you will be found liable for common assault. If you were found to be charged with assault GBH, assault with intent to cause grievous bodily harm, then what would happen is that the presence of intoxication or proof of it will just eliminate the specific form of intent there, and then you will still be guilty of common assault. That was the situation. The law adopted what was or could be described as an unyielding approach. It never yielded to intoxication, and this was based on public policy. So public policy deemed it that people who are intoxicated and go about and commit crimes or abuses of the law should not be afforded defenses at law and should not be treated differently from a sober person. That was the position in our law prior to 1981. Now, to give you a brief example of that policy, let me just read an expression that comes from one of those cases, just to make it clear for you to just understand this concept of an unyielding approach. In the case of Borg, for example, it was said that, is it true that absolute drunkenness is equivalent to insanity? I submit not. The essential difference between a drunken person and one who is insane is that the former, as a rule, voluntarily induces his condition, whilst the latter, as a rule, is the victim of a disease. It is therefore not unreasonable to consider that the person who voluntarily becomes drunk is responsible for all such acts as flow from his having taken an excess of alcohol. It would follow that the regular drunkard would be more immune from punishment than the sober man. So those were the comments of the judge in the case of R versus Borg in 1916. And likewise, in the case of Johnson, the comments that were reflected upon reflect in the case of Johnson, the accused was an 18-year-old boy who was arrested and put in jail for being drunk in public. So in that instance, while he was in the jail cell, he assaulted somebody with a bucket, another inmate with a bucket, while in a state of intoxication, and killed that person. He was charged with murder, and the court held that despite the psychiatrist saying that he was intoxicated to the point that he did not know or appreciate what he was doing at the time, the court nevertheless held him guilty of culpable homicide on that basis. The court, as public policy, intoxication or the presence of it does not excuse your behavior. The position changed in 1981 because of the case of Cretin. Now, in Cretin, there was X who went to a party and drank, enjoying his social, and then left because he was involved in some sort of an altercation or some discontent. So he got into his car, his Volkswagen Kombi, and was about to leave and hit 5 people who were actually 6 people who were standing on the road while he was trying to drive away. In evidence during court, he submitted that he believed and thought that the individuals were seeing his car and would move out of his way as he drove closer. So the trial court decided that on that basis of that evidence, it was evident that the accused did not have the requisite intention. He was charged with murder and attempted murder. Murder because 1 person died, attempted murder because 5 individuals were injured. So then what happened is that the court then held him guilty of culpable homicide for the death of the 1 person on the charge of murder, and then for the injuries of the other 5, the court acquitted X of attempted murder, but also went further to acquit X of common assault, and that triggered the state to launch a question of law as to whether it was right for the trial court to have not convicted X of common assault on the attempted murder charges, if in those instances it is proved that X did not have intention or the requisite intention. And so the court went and reflected on the principles of law concerned. It reflected on the cases of Borg and the cases of Johnson, and came to the conclusion that we cannot elevate policy above jurisprudential reason and logic and principle. So we have to follow principle. If a person says, or if it is proved that because of intoxication, somebody was so severely intoxicated that they were acting in muscular movements, their acts were involuntary, then there is no question of an act that has been performed. And if an act has not been performed, then X is not guilty of that crime and should be acquitted. If it is found due to intoxication that somebody was able to act but lacked criminal capacity, or was so intoxicated as to be unable to appreciate that his conduct was unlawful, or appreciate the wrongfulness of his conduct, or his inhibitions were substantially curtailed. In other words, he could not act in accordance with an appreciation of wrongfulness, then he or she would lack criminal capacity and would not be criminally liable. If indeed X was so intoxicated that, for example, in a case of an assault, he did not foresee that death will take place as a follow-through from the assault, then in that instance, the accused will lack intention, and such lack of intention will result in him not being guilty of a crime requiring intention. And the court went further to say that therefore the specific intent theory that actually comes from English law is no longer applicable, should not be followed. And on that basis, because we accept that intoxication may affect intention and may exclude it, it is impossible for an accused who is charged with a crime requiring intention, like attempted murder, to still be convicted of common assault, which requires intention, because intention is intention. So if X lacked intention, then X cannot be guilty of any crime that requires intention. And then the court went on to say that the court, at the same time, the courts must not be too quick to come to the conclusion that someone can be so intoxicated as to lack criminal capacity. Otherwise, if the courts go readily to determine or conclude that an accused lacks criminal capacity as a result of intoxication, then the administration of justice will be brought into disrepute. So it must not be lightly inferred in particular that intoxication does have that effect or has effectively eliminated criminal capacity. So as you can see, the court ultimately decided that question in the affirmative. It said that the trial court was right to conclude that X on the charge of attempted murder could not be guilty of common assault, because once the court accepted that X lacked intention, then X could not be guilty of common assault and would have to be acquitted entirely. So the long and short of that, not to confuse you, these are the clear effects of intoxication as accepted by the case of Cretin in 1981. Intoxication, depending on the degree of intoxication. I think this is the important thing that I want to emphasize. The court said it is important for courts to assess the degree of intoxication. It's not a ready-made conclusion that once there is intoxication, there's definitely an effect on liability. The question is, what is the degree of intoxication? How severe is the state of X's intoxication? And so the court held that X can be in the most severe state. X can be so intoxicated as to lack the voluntary requirement of an act, and therefore not comply with the act requirement. And in the less, just underneath that, X may have acted voluntarily, but it may be proved that the extent of his intoxication was such that he could not appreciate the wrongfulness of his conduct or act in accordance with an appreciation of wrongfulness, in which case X would lack criminal capacity. And then below that, it is also possible that X, because of the state of intoxication, may still have voluntary conduct, may still have criminal capacity, but may lack intention in that he or she did not foresee the possibility that death may occur and did not reconcile themselves with that. So the result here is that intoxication could result, according to Cretin, to a complete defense, excluding liability. Now, let me stress something. We are not only talking about intoxication caused by drink, we are also talking about drug-induced intoxication. So when we talk about the principles of intoxication, they apply equally in the case where X maybe has inhaled drugs or has taken drugs of some sort, and they cause him or her to be intoxicated and to be in a certain state when they perform an unlawful act. Now, naturally, the state at that time was not happy with the finding in creatine, and the legislature decided to pass a piece of legislation called Section 1 of Act 1 of 1988. It passed that piece of legislation in 1988, and in passing that legislation, the legislature decided or had to make a determination as to which element of liability would they focus on, as far as what creatine decided to reverse the impact of creatine. And the legislature decided in its wisdom at that time that if X lacks criminal capacity, then effectively there is no crime that does not require the existence of criminal capacity. So if X were to escape criminal liability because of lack of capacity, then effectively it means X will go scot-free from any form of liability, because all of our crimes require or presuppose that X must have criminal capacity. So please make sure that you understand that the legislature targeted specifically lack of criminal capacity in its elements of that crime as a focal point for its provisions. You have to know and understand the elements of the statutory offense in detail. The elements of that offense are given to you. We tabulate them on page 180 of your study guide. You'll see those elements A1 to A4, B1 to B3. It is important that you are able to state these elements. It is important that you are able to articulate them in an exam context or in any form of question that is asked of you. Now, according to those elements, the first element is it must be proved that X consumed or used a substance that impairs her faculty or his faculties to such an extent that they lack criminal capacity, while they know that the substance has that effect. And then following from that, it must be established that whilst in that condition whereby criminal capacity was lacking, he committed an act prohibited under penalty, meaning an unlawful act, a crime, while lacking that, and because of the absence of capacity, was found not to be criminally liable and acquitted. So you can immediately check from those elements that this crime was formulated to target the outcomes of the creatine judgment, and especially the outcomes that affect lack of criminal capacity. Now, the question then becomes, practically speaking, what does this actually mean? Because on the one hand, when the prosecution goes out and tries to establish that X is guilty of murder, for example, they have to prove the element of criminal capacity beyond a reasonable doubt. That means that if X were to say, I was intoxicated and the state of my intoxication was such that I could not appreciate right from wrong, or I could not act in accordance with the appreciation of wrongfulness, then what the prosecution needs to do is that it needs to it needs to challenge that defense by establishing that X was not so intoxicated as to lack capacity. In other words, it has to prove the existence of criminal capacity beyond a reasonable doubt. Now, according to Section 1, if the court were to say that at the end of the hearing or upon judgment that the court believes that the version of the accused could reasonably possibly be true, meaning that there is indeed reasonable doubt that X lacked criminal capacity. If the court finds in favor of the accused, then the accused has to be acquitted from that charge. Now, obviously, if the accused is acquitted from the charge, it means that the prosecution can have a second bite by virtue of Section 1 of Act 1 of 1988. But now, effectively, it has to make a complete about turn. Whereas at first it went out of its way to prove liability. This time under Section 1, it has to prove non-liability. It has to go out of its way to establish beyond a reasonable doubt that because of intoxication, X lacked criminal capacity. And it has to prove that element beyond a reasonable doubt. So the interesting dynamic here is that the prosecution is put on a complete about face. And in a number of judgments that were decided, the courts had to reflect on what these principles actually mean. So let me just go to those judgments. The first of these is State versus Lange, 1990, Volume 1, SACR 199W. The accused had been charged with housebreaking with intent to steal and theft, and raised the defense of intoxication, which succeeded on this charge. But the question arose as to whether the accused had correctly been convicted of contravening Section 1 of Act 1. Ultimately, the court confirmed the conviction of contravening that section. But in the course of its reasoning, it went as follows and said, on behalf of the appellant, it was submitted that the act requires that the accused must know that liquor has the effect of preventing him from appreciating the wrongfulness of his act or acts. In other words, according to the appellant's counsel, it must be proved that the appellant subjectively must have an appreciation of the fact that they might commit a specific wrongful act. Therefore, if a person knows that after the consumption of alcohol, he normally acts in a certain manner, he cannot be held liable if on a particular occasion he unexpectedly acts in a manner which is unlawful and quite contrary to the normal certain manner that he expected. That was the argument on X's behalf. And then the court responded by saying such a subjective approach is, on the ordinary wording of the section, very untenable. All that is required for that requirement of knowing that the substance has that effect on him is a general understanding that the substance, either the drug or the alcohol, does have the potential to impact his or her faculties. And on that basis, the defense raised by X did not succeed in that instance. But both in the case of Lange and in the case of Mbele, the court, Mbele is 1991, Volume 1, SA 307W. In that case, the court said the following. In the present case, the magistrate did not find that the accused's faculties were in fact impaired at the time of the events. According to his judgment, he only held that the accused's evidence of his incapacity might possibly be true. It was an aspect on which he merely had doubt. As a result of what has been said already, this was insufficient to prove the elements of the crime. So in other words, what Mbele said, which was to be later confirmed by the appeal court in the case of September, is that it is not sufficient that the court prove or come to a conclusion that there is reasonable doubt as to the existence of criminal capacity. That is not sufficient. That may be sufficient to acquit X on the initial charge. But in order for X to be convicted of Section 1 or contravening Section 1 of Act 1, proving doubt as to the presence of criminal capacity is not sufficient, because what the section requires, it requires that you prove non-liability. The accused must not have been criminally liable. That means effectively the prosecution has to prove that element beyond a reasonable doubt. And in the case of September by the appeal court, this is decision 1996-1 SACR 325A. The court said the following: if the accused is acquitted as a result of the state's onus on the grounds of reasonable doubt as to his criminal capacity, that is insufficient. Firstly, because a finding that his faculties were indeed impaired is absent. And secondly, because in the absence of positive evidence of such impairment, a contravention of Section 1 is not proved. In other words, Section 1 is a provision that creates an offense, which, according to trite principles of law, requires proof beyond a reasonable doubt from the state that the accused's faculties were indeed impaired and that he was therefore not criminally liable for a prohibited action committed by him in his drunken state must be positively proven beyond a reasonable doubt. If mere doubt just exists about his criminal capacity, he can neither be found guilty as a result of their action under subsection 1. So the appeal court in the case of State versus September 1996-1 SACR 325A affirms that that element must be proved beyond a reasonable doubt. Now, to conclude, we go at the end of the section. We then give a table of the principles of our law. That if X is so intoxicated that they are incapable of committing a voluntary act, they would be found, according to Chrétien, not guilty of the crime charged, but they would be found guilty in terms of contravening Section 1 of Act 1 of 1988. Why is that? Because if somebody is so intoxicated as to lack voluntary conduct, implicitly they are also lacking criminal capacity, because that is the most severest form of intoxication. So if a person is found to lack voluntary conduct because of intoxication, then they are not guilty in terms of the original crime charged according to the principle of Chrétien, but will be guilty in terms of Section 1 of Act 1. If they are so intoxicated as to lack criminal capacity, the same principle applies. They would not be found guilty of the original charge because of Chrétien, but will be guilty of Section 1 of Act 1 of 1988, which specifically focuses on lack of criminal capacity. Now, we have not spoken at length about the impact of intoxication on intention. And the question that would naturally be asked is, if the accused lacked criminal capacity, if the accused had voluntary conduct and had criminal capacity, but only lacked intention, does Section 1 of Act 1 of 1988 apply? The answer to that is no. Section 1 of Act 1 of 1988 would not apply. So X would not be found guilty of that original charge based on the principle of Chrétien, and will not be guilty of Section 1 because he had criminal capacity at the time, so did not lack criminal capacity, only lacked intention. So having escaped, though, a crime requiring intention, they would be guilty of a crime requiring negligence, and that would be culpable homicide, as was the case in the case of Cretin. And again, as was the case in the case of State versus Marohanye, the Jup case. If you remember, that is the case of Jup and Temba Chabalala driving their Mini Cooper cars in Mufulo Street in Soweto, Protea. They struck children there with their vehicles, and there were 2 children that were injured, and 4 others that died as a result of that. So they were found to have taken drugs, and according to the court, they were in a state of euphoria. The drugs caused them to be in such a state of euphoria that they did not foresee the possibility of killing anyone, or killing the students concerned, or anyone in that vicinity. They did not reconcile themselves with the possibility of killing, through their vehicles and behavior. So according to that case, on the charges of attempted murder, they were acquitted. And they were only found guilty for culpable homicide as far as the charges of murder in those instances. So those were the principles that, according to drugs, they were unable to appreciate, to foresee the possibilities of death, and they did not reconcile themselves with it. Now, if charged with a crime requiring negligence, intoxication is not a defense. It does not exclude negligence, because remember, we always compare the act of X according to the conduct of the reasonable person, and the reasonable person, according to the law, would not recklessly cause themselves to be in a state of intoxication and commit crimes under that state. If X complies with all of these requirements, including intention, he will be guilty of the crime that requires intention, and will be the concept of intoxication, though, can be taken into account at the point of punishment. So that is the conclusion as far as the effect of intoxication is concerned. On page 185, 184 and 85 of your study guide, we talk briefly or summarize briefly. In particular, 185, we summarize briefly the effect of provocation. I would encourage you to also see tutorial letter 102. In tutorial letter 102, we articulate the certain amendments on study unit 12 and study unit 13. Please note that the information and the details and the cases that are discussed in tutorial letter 102 are meant to supplement your study material. So you have to read the contents in tutorial letter 102 as part of the discussion in your study guide. Make sure that you understand the cases and the principles that are articulated in that tutorial letter. We have covered quite extensively the effect of provocation when we spoke about the case of ED. So the principle applies as far as ED is concerned. The only way that X can escape liability if they allege that because of provocation or emotional stress, they were unable to act in accordance with the appreciation of wrongfulness, they would have to prove sane automatism. The only way they can escape liability is if they establish that they acted involuntarily, which is a very, very difficult proposition for a defense lawyer to establish. And that brings us to the end of Unit 12. Now, when we come to Unit 13, I want to stress the following. It is not, you do not need to study Unit 13 for exam purposes. we make it explicitly clear that we can utilize it for the purpose of assignment questions and assessments. But Unit 13 is not, Unit 13, you may just read through it just to understand it or to familiarize yourself with situations in our law whereby culpability as an element is disregarded in our law. Now, all of these things that are discussed in Unit 13 must be contextualized as pre-constitutional situations. In pre-constitutional times, there was a concept known as strict liability. This is a situation whereby culpability is proof of culpability is not important. The legislature could create crimes that do not specify concepts speaking to culpability, either in the form of intention or negligence. And then the courts were required to determine, according to certain principles, whether that act requires culpability or not, despite the absence of anything expressly articulated by the legislature. So in those instances, for example, if there were instances whereby we're talking here about food manufacturing companies or public welfare cases, let me just to express the concept very clearly. I want to make sure that I capture what Sneeman has to say here. This is on page 236 of the 6th edition, whereby Stayman talks about strict and vicarious liability. And he starts off by saying, the expression strict liability means liability in respect of which the requirement of culpability is dispensed with. It refers to the rule applied by the courts in the past that there are or may be certain statutory crimes in respect of which no culpability is required. Strict liability is encountered only in crimes created by statute. It plays no role in common law crimes. In these crimes, culpability is unavoidably required. So where would strict liability usually have come in? Until roughly the 60s of the past century, meaning 1960s and before then, the courts often interpreted the definition of statutory crimes in such a way that culpability, either in the form of intention or negligence, was required. However, since about 1970, there has been a significant decrease in the number of cases holding that a statute has created strict liability. As far as could be ascertained, since 1970, there have been only 3 cases in which a court has interpreted a statute as being one creating strict liability. This decrease can be attributed to the continued criticism of the principle of strict liability, as well as the greater willingness of the courts to hold that the legislature tacitly requires culpability in the form of negligence. So in other words, over time, from the 1970s onwards, the courts adopted the principle that culpability was always required. At the very least, negligence would be required. In the form of culpability required would be negligence. Now, according to the principles of strict liability, what the court was required to determine in those times were the following principles: language and context of the provision, the object and the scope, of the legislation, the nature and extent of punishment, the ease which the provision can be evaded if culpability is required, and the reasonableness in not holding culpability as a requirement. Now, obviously, since the 1994 and 1996 Constitution, there is extreme doubt whether strict liability is still something that operates in our law today. According to certain obiter dicta, especially the case of State versus Gutierrez by the Constitutional Court, Justice O'Regan disapproved of strict liability under our constitutional dispensation, and especially stressed that Section 35(3) of the Constitution, which is the right to a fair trial, and Section 12 of the Constitution, which guarantees freedom and security of the person, are such that they place a burden that it is required that there be culpability. The accused has to have performed the crime with a blameworthy state of mind. Now, as I was preparing this, I actually just chuckled with myself and found it interesting, because we had the case of the President of the Republic of South Africa versus the Public Protector, and those that had occasion to read the judgment delivered by the Constitutional Court or to reflect on what was said about concepts such as willfulness and inadvertentness. That's a typical example of a situation whereby the legislature in the code expressly articulates culpability by using the word willfully, because willfully speaks of intention. Other words that are used to express intention would be maliciously, would be fraudulently, would be intentionally, or dishonestly. Such concepts speak to the legislature requiring that there must be proof of intention. A word like inadvertently, or the absence of such wording, may reflect that all that is required is negligence and not intention. So it is important that the courts adopt the right principles of interpreting statutes, and they determine as to what form of culpability is required in each such instance. Another instance of strict liability is vicarious liability. It's just a form of strict liability. This is an instance whereby one person is held criminally liable for the acts of another person. Usually that other person would be somebody who was acting on behalf of that first person. So although A did not directly commit the crime, but B committed that crime acting on behalf of A, then what happens is that A would be found to have been criminally liable vicariously because of the actions of B. Another form in which strict liability was applied, and we discussed this briefly, was the Vasari Doctrine. According to that definition, as you can see, if a person engages in unlawful or merely immoral conduct, she is criminally liable for all the consequences flowing from such conduct, irrespective of whether there was, in fact, any culpability on her part in respect of such consequences. In other words, if a consequence happens and X did not foresee that, or X could not have foreseen that as a consequence from their immoral or unlawful conduct, they would be held to have had culpability for that other conduct, despite the absence of subjective foresight as far as dolus eventualis is concerned. So that's a form whereby culpability was dispensed with. It was rejected, as we said, in the case of Bernardus. The other expression of strict liability that we speak about, or at least where culpability is discarded, is in relation to corporate criminal liability. This is where, for example, companies can be held to have committed crimes, and they would have been held to committed crimes because of the actions of their directors or their servants. So as you know, in our law, companies are not natural persons, but they are juristic persons. They have a personality recognized by law, and as such, they can be criminally liable. And that is regulated by Section 3321 of the Criminal Procedure Act. It provides that an act by a director or servant of a company will be deemed to be the act of that company itself if that act was performed by the director exercising his powers or furthering the interests of the company. And we have examples on your study guide in page 190. For example, A was a transport company and B a bus driver employed by A. B caused an accident whereby someone is killed because B had allowed a passenger to drive the bus. Both A, the company, the transport company, and B are convicted of culpable homicide. Another example there, company A's director, B, in an attempt to eliminate competition with another company, steals valuable diagrams from the office of company Y. If charged with theft, both A, the company, and B, because it was director, are guilty of theft. Company A's director B murders the managing director of company Y in an attempt to promote the interests of A. So obviously trying to eliminate competition. A and B are both guilty of murder, B being the director or the person or servant concerned, and A being the company. So these are interesting dynamics, obviously, because you think of instances like VBS, you think of instances like Steinhoff, and the question is, can those companies be found guilty of the crimes committed by their servants and their directors? I put it to you that if indeed there is an appetite on the part of the state or the National Prosecuting Authority to implement Section 3321 of the Criminal Procedure Act, those companies can be found liable for fraud. They can be found liable for corruption or money laundering or racketeering. I would put it to you as well that effectively, even the case that Mr. Zuma and Thales are dealing with in terms of the arms deal, which will be heard sometime next week. The reason why Thales is in the dock as a company is because its directors have committed potential crimes, and those potential crimes implicate that company. So the company is in the dock, and the company itself can be found liable for those crimes if the elements of liability are proved in relation to their directors. So those are that is in short what we cover in Unit 13. As I have said, it is not examinable for you to actually study it. It is just interesting for you to know, and you need not study it for the examination. That brings us to the end of our lecture today. Thank you very much. I will take questions now. Okay, I see the hand of Tulu. Tulu, can you unmute your mic, please? Okay.
Good afternoon, Prof. Okay, I'm sorry. I don't know if maybe you explained this and then I missed it. In the case of Jub Marohani and Chabalala, I just want to find out, like, the court says they were in a state of euphoria. So I just want to find out that did they act voluntarily or involuntarily while in that state?
Thank you, Tulu. That is a very good question to ask. The court found that they did act voluntarily. They were able to subject their body movements to their will and intellect when they got into the car and started driving. But the issue is that the degree of their intoxication in terms of the use of drugs was only sufficient to exclude intention. So they did not lack voluntary conduct. They did not lack criminal capacity, but it was found that they lacked. They were sufficiently intoxicated to the point of lacking intention. Hopefully that answers your question.
Yes, it does. Thank you.
Okay, any Mahudu, please, you can unmute your mic.
Good afternoon, Prof. It's David here. I happen to use the device for any anyway.
Okay, go ahead. Go ahead.
My question is it's with regard to the intoxication. I heard you said of course the court needs to determine the degree of the intoxication. How do we determine the degree of intoxication, Prof? Thanks.
Okay, very good question. That will obviously be if you are an accused person and you're faced with a charge, it will really be up to you and your lawyer to establish reasonable doubt that you had any of the elements of liability talked about, either voluntary act, criminal capacity, or intention. And to establish that doubt, you would have to produce or bring an expert evidence on your behalf, either in the form of a psychiatrist or a psychologist, somebody who would have to establish your levels of drunkenness as well, and establish how it affected you, what will be your normal propensities during those times when you are intoxicated. That is how you would establish, at least from your point of view, you would establish that you were intoxicated to a certain degree, that you either could not control yourself, which would mean voluntary conduct is lacking. Either you could not appreciate that your conduct was wrongful, or you could not control yourself in the sense of lacking the criminal capacity, or you could not foresee that you would commit a crime, and you could not foresee that death would happen, and you did not reconcile yourself with that. Does that answer your question?
It does, Prof. It does, Prof. Thank you very much.
Okay, please mute your mic. Thank you. I'm now going to allow Lituma Bosaletsi. You can unmute your mic.
Good afternoon, Mr. Ramos.
Afternoon, Lituma.
Yes, thanks very much for this opportunity. I just want to know myself, like in terms of where under intoxication, if someone is being forced to commit an act, like for example, let's say you go somewhere as friends, you go to a farm somewhere, it's a getaway for a weekend away, you are there. Whilst you are there, you are all intoxicated, and by some mistake, someone is bitten by a snake, and maybe you try to call the local hospital, and they say the ambulances are out, and there's no ambulance that can come quickly now, and the person needs to be rushed to hospital. Then as a result, you know that you are you are all drunk, and now someone gets inside under the level of that intoxication, then drives, and on the way maybe caused an accident and all that. So will that be also an issue? Because given circumstances that you knew that you were drunk, but you were somehow maybe forced to save someone's life in a way.
Okay, it's an interesting set of facts. But let me ask you this question. What would you be charged with?
Maybe being under the influence of alcohol while driving.
Okay, so yeah, driving under the influence. Okay, then you will have to maybe there are two levels to this. The first potential defense that you can raise would obviously be necessity. That's if you satisfy those requirements of necessity, but it seems to me that at the very least there might be one requirement that stands in your way. And that requirement says that you must not have been responsible for creating the situation of necessity. So if indeed you created that situation by being drunk and being irresponsible, we'll assume now that you lack that element and you are found to have acted unlawfully, then yes, the question would come to your culpability. And as I understand it, driving under the influence of alcohol requires intention and negligence, if I'm correct. So negligence would also suffice in such instances. So I don't think you will really escape that particular charge, because negligence is a sufficient form of culpability. But let's say, for example, you knocked somebody over and a pedestrian died. In those instances, then you'll be charged with murder, and the question would be whether you were intoxicated to the degree that your intention was lacking. You'll have to use the normal principles, of course, of cretin. And did you foresee the possibility that you would knock someone over, and did you reconcile yourself with that? If you did, you'd have intention, and you'll still be guilty of murder despite the degree of your intoxication. But if your intoxication was to such the degree that you did not have foreseeability, subjective foresight, and did not reconcile yourself with the possibility of killing someone, as happened in the Marohani case, then you'd not be guilty of murder, but you will be guilty of culpable homicide because you have been negligent. Does that answer your question?
Yes. So in that circumstances whereby somehow someone find himself forced to do something, let's say as I gave you an example, maybe it's better to stop to commit an act, like as if you are sitting there and someone is bitten by a snake, dangerous snake, and if it's not at the hospital by certain time, and then there's nothing else you can do, and you know that you're all drunk and ambulances are not available at that point in time. So the best way is to let go.
No, as I said, I think the use of the word forced maybe may have confused me. If by forced you are actually saying that you were in circumstances that you had to act urgently, or under a situation of emergency, which I understand you to be saying, then I submit to you the same as I have said. You would more likely be asked as to whether the state of your intoxication was such that you lacked intention. Did you lack intention? If you lacked intention because of the degree of your intoxication, then you would would not be found guilty of the crime of murder, assuming that you knocked somebody over. in the course of rushing that person to hospital. You will not be found guilty of the crime of murder, but you will be found guilty of culpable homicide. But if you were just talking maybe about driving under the influence of alcohol or liquor, as I said, I believe, and my colleague, Professor Molema, if you are here, I believe negligence is also a sufficient form of culpability for that crime. I would defer to you, Prof, to clarify that and affirm that. But if it was a question of under the influence, then the question becomes, can you rely on necessity, for example? And as I said, necessity requires certain requirements that you'd have to satisfy. And immediately in my mind, one of the requirements that might be a stumbling block for you, which you'll have to consider, is that you must not have created the situation of acting under necessity, in order for you to rely on it. And you might fail on that, but then again, you might be successful. So it depends on what the circumstances really boil down to. Have I answered you?
Yes, I think you have answered.
Are you sure?
Yes, I think I know. I think you have answered. It's gonna depend on that circumstances that cause that necessity.
Yes. It will definitely depend on the crime you are charged with. That's why I began by asking the question, what crime would you be charged with? If you are saying driving under the influence of alcohol or negligent driving, then I would say you'd begin by trying to challenge whether you acted lawfully, and you try to rely on necessity. If necessity does fail on your behalf, then you can perhaps try and say that you were too drunk, that you lacked the fault requirement. But then I put it to you that because that offense just requires proof of negligence, you are not likely to succeed with escaping liability for that crime.
All right.
Okay. Siabonga, you can unmute your mic. Siabonga Sikumbuzo, I believe it's Sikumbuzo. I can't. Yeah, Sikumbuzo.
Can you hear me, sir?
I can hear you.
Okay. I hope you could say. Pardon me if the questions that I'm about to ask you have indirectly answered them. I have only two questions here. If I'm not mistaken, the use of drugs in this country is already prohibited by law as long as those drugs are not prescribed by a medical practitioner. So my question is, how come can a legal person depend on something that is already prohibited by law as his way to escape liability? And the second question stems from page 172 of the study guide, from 12.4.3, the remaining instances of voluntary intoxication. Yes. Let me create a scenario here. Let's say Y is drunk, and out of his drunkenness, he exchanges harsh words with X, and after that, Y takes an empty bottle of a beer. He crushes it. He crushes the bottle in a big stone to create a razor-like bottle, and then so he can stab X, and then X, out of self-defense, he knocks Y down with a fist, and Y falls back with his head, and then he crashes his head on this big stone, and then he dies. What will be the fate of X? I'm not sure if you understand my question, sir.
Yes, I have understood your question, Sikumbuzo. That situation sounds to me like a situation whereby X can rely or at least allege that he was acting in self-defense or private defense, X would then have to establish the requirements of private defense and satisfy those. And perhaps the key requirement would ultimately be whether X in his response did not exceed the bounds of private defense. Was his response, defensive response, in reasonable relationship or proportional to the attack that he was facing? If X manages to prove that his response was reasonable, then he would rely successfully on private defense. Does that answer your question?
Yes. So, the second question, the first question, did you hear it? The one about drugs.
Oh yes. Oh yes. Thank you very much for taking me back to that question. No. Obviously, that individual will probably be charged not only with culpable homicide or murder, as the case may be. They will also be charged with contravening Section 4 of the Drugs and Drug Trafficking Act. They will be found guilty of use or possession of drugs.
Okay. I hear you. Thank you.
All right. The final hand I see is that of Tandaza Potwana. You can unmute your mic, Tandaza Potwana.
Hello, Prof. How are you?
I'm well, thanks, and you?
Oh, wonderful. It's my first time to attend and due to work. You know, I literally cannot attend. I would love to, but unfortunately the situation doesn't allow. Today, I am just so over the moon, excited about the class that I've attended. So my question is not going to be basically on the content of this. My question is based on, okay, because I'm working, I'm sure maybe there are other people like myself that are working. How do we get these recordings so that at least even if we miss them, but we may be able to find them so that they may help us? You know what I mean? This is very profitable, I tell you now.
No, thank you for asking, and your question is very, very valid. And for all the students that are still here with us, I want to also extend this answer to everyone who may have registered late due to circumstances beyond their control. We acknowledge you. We acknowledge you as part of this module. Please don't feel disadvantaged in any way. All the recordings for the online lectures will be found under the announcements page or the announcements menu on the My UNISA site. So if you open that announcement menu as broadly as you can and go down, even to the beginning of the announcements, you will see that at every point we have a link to the lecture, we have the recording, we have the slides also that are used here. They are attached and available for you to use. So if you go to the announcements page and you go just right down, you can access every lecture. And if for some reason you find challenges and are unable to do that, please send me an email or send us an email requesting for that specific link. And I will provide it for you at no, you know, with no qualms and no challenges.
Oh, thank you very much, Prof. I really appreciate it. Thank you very much.
No, we appreciate you, and I want to say for all students that are here or listening, please bear with us in terms of your assignment ones. There are just so many assignments and they are still in the process of being marked. You will not be disadvantaged. As long as we have received your assignment, you will get back your assignment mark. So please do not be disheartened if you hear of your other colleagues having received their assignments and you are still waiting for yours. It is still on the way. Thank you very much for your attendance. If you have any questions, please feel free to send an email to us. Please feel free to also put your questions on the discussion forums. We will do our best to regularly check your questions and answer them as much as we can. So we just request your patience. But if it's specific to you, I would strongly advise that you send us an email directly to the lecturers. Don't post a specific query that focuses on your own challenges in the discussion forum. Rather, come and send an email directly to us. Thank you very much for your attendance. Next week we will cover participation, which is Unit 14. I really urge you to be part of it and to also spread the word about next week's lecture. We'll be covering things like common purpose. We'll be covering things like, what happens if there are more than one participants that are involved in a crime, like a robbery, cash in transit heist. Many crimes in this country are performed in groups. What are the principles of our law in such situations? You will not lose, but you will gain a lot by being part of that lecture. Thank you very much. I see the hand of Becky. I will take your hand before concluding this lecture. You can unmute your mic, Becky.
Thank you very much, Prof. Can you hear me?
Clearly.
All right. Sorry, Prof, to deviate a bit. I just want to know what if a student is not happy probably with the marking received from assignment 1, not necessarily that the person failed, but it's more concerned about the percentage granted. Can that person appeal that or send an email direct, or assignment are not considered as something that can be opposed?
No, you are well within your rights, and I want to extend this to every student that is here and those that will access the recording. If you have any concerns about the marking of your assignment or the comments that are given, or you want some sort of a review, we are available as your lecturers. Please send us an email. Preferably when you send that email, give us your student number and also attach that assignment if you can. But if you are unable to, we are still able from our side to access that marked assignment. So please do not hesitate to send your queries, and we will give you as comprehensive a feedback as possible to make sure that you understand where you went wrong and why you got the result that you got.
All right. Thank you very much, Prof. I'm answered.
Thank you very much. I want to also acknowledge Professor Molema, who was with me in this meeting as well, or the lecture, and all my other colleagues who were able to also be present. Thank you very much. Please note that the notes and the actual recording will be posted on the announcement page for this lecture. Thank you very much. Enjoy your day.